Hello, everybody, and welcome to the last law lecture for the semester. Okay, so tonight we're going to talk about, or today, depending on when you're listening to this, we're going to talk about FERPA, which is student privacy, open records law, and legal issues pertaining to student athletics. Okay, on top of that, at the end, I'm going to give you some brief comments about the study of higher education law in general, and then we're going to go over briefly the final exam. So make sure you listen to the end to get some good instructions on the final exam. Okay? So, as always, you have some PowerPoint slides that are accompanying this, so please take a moment to check those out. Follow along if you want, or download them later whenever you want to, okay? So the first two slides are basically title slides that take us from the main topic to the first topic, which is FERPA. Now, FERPA is an acronym. It stands for the Family Educational Rights and Privacy Act. It was originally known as the Buckley Amendment and was part of the 1974 Higher Education Amendments. Ultimately, the purpose of it was to provide protection for adult students, meaning 18 or older, or younger if they're engaged in higher ed activities. So let's say you have a student who is engaged in courses at both their local high school and at the local community college. Okay, so let's say they're taking courses back to back, okay? Dual enrollment. The courses they're taking with the college will fall under FERPA protection for them, meaning that they would have to give their parents permission to look at those records. Whereas what they're going through at the high school, their parents have access to that because they're still the legal guardian. But anything they participate with higher ed, we provide FERPA protection to them, okay? So, a university or college cannot release FERPA protected information to a third party without students' permission, okay? FERPA not only gives this protection, but it gives the students the right to inspect their educational records at any point to ensure accuracy. So basically, if a student wants to see their transcript, we have to allow it. If one of you want to see your grades for the semester, I have to allow it, okay? There's a certain time period that I can get it to you, which we'll talk about in a minute, but we do have to give you that information, okay? Now, we've already talked about who it protects, parents of children 18 or older, parents of children under 18, individuals who are over 18, or if they're studying in college in general, okay? Now, what are the records it protects? This is any educational record pertaining to students and is maintained by the educational institution. These records are predominantly things like transcripts, which have to be kept forever. Even if an institution closes, the institution must find another institution to house those transcripts. Okay, and this is even the person can die years afterwards, they must still be maintained. Okay, any record related to students' educational records, such as test scores, academic standing, etc., any disciplinary action. Okay, so anything that a student may have done that have warranted like academic legitimacy issues, violations of student conduct, student handbook violations, all of that stays in the record for good. Okay, any financial information. Personal information such as social security number, gender, residency status, religious preference, race, all of that is FERPA protected information. Now, if it is a protected record, then a student must be allowed to view that record after making a formal request. Okay? A university or college must comply, according to federal standards, they must comply within 45 days of a written request. Generally, you want to reply sooner, but you have up until 45 days, okay? Any kind of exceptions to FERPA are records that are maintained by law enforcement. This is part of the Higher Education Act of 1992. School officials who have a legitimate reason to review student evaluation records, meaning that other professors in a program, so if let's say you're in the history department, and I wanted to go and see what you were doing over there, that's not appropriate. I'm not allowed to do that. I'm not part of that program. But in this program, if I and another professor who are also teaching you need to review your records, we can do that because there's legitimate academic reasons to compare student performance across a program, okay? So academic advisors can generally see any of your records, registrar's office, financial aid, human resources, institutional research, etc. Any of those offices can generally look at your material, okay? Other exceptions to FERPA is anything in connection with a safety emergency if necessary to protect students or others. This generally deals with history of any kind of student conduct. So anytime there's a student issue and we need to look back into their history of student conduct, that's generally when there's going to be exception, particularly if law enforcement asks for it, okay? Anything dealing with parents of students who are dependents for tax purposes, we have to provide tax returns, although we don't have to provide any information on grades or things like that. Other kinds of exceptions are directory information. So this is slide 10. This is things like your name, where you live on campus, though that one is becoming less and less provided, mainly because of student security. Telephone numbers, email addresses, date of birth, place of birth, any previous institutions that you've attended. This is open information. Any degrees that you've earned, when you attended institutions, what are your majors or classification, and for student athletes, height and weight. Okay, mainly because they want people who may look at them for professional teams to understand those facts about them. Okay. Now, another thing to understand about all that directory information is, though it's allowed to be disclosed under FERPA, most universities will allow a student to request the information not be released to a third party. Okay? This is commonly called a privacy flag, meaning that a student can kind of say, I don't want any directory information out there. I don't want any of this provided. And we have to comply. We would have to say, okay, your information has been coded as private. There's a privacy flag. If anybody tries to request it, an email will be sent to you and you can approve it or disapprove it. Okay? Now, other exceptions to this, and this is generally if you ever work in registrar's office or anything with academic affairs, this comes up a lot. Students can sign a consent which allows personally identified information or educational records to be released to parents or spouses. Okay, not a third-party vendor. Okay, it has to be somebody of relation and close relation. So it has to be a guardian, a parent, a spouse, somebody that you actually have, or a partner of long-standing. That has to be illustrated that you've been in that relationship for a while. These consent forms need to be explained thoroughly. So when somebody asks for one, somebody from academic affairs, the registrar's office, needs to explain what these forms are. The student has the right to decline the consent form. Often this becomes a problem when parents want to have access to student records and students say no. The parent will say, well, I'm paying your tuition. The student still has the right to say no. The university looks at the parent as providing that tuition money as a gift, meaning that the parent can choose not to pay that tuition. Okay? But because the parent is paying that tuition for the student, that is a gift. That does not provide any rights. Okay? Now, regarding FERPA and legal entities, educational records can be released after a subpoena has been warranted. We do deal also with the Patriot Act. The Department of Justice can subpoena educational records of suspected terrorists. This is generally going to deal with any kind of behavioral background, disciplinary record, or travel records in and out of the country. Okay. There are some violations to FERPA that need to be considered. When there is a violation, the United States Department of Education is charged with enforcing FERPA violations. The Department of Education can withhold federal funds to institutions for mass violations, and no private cause of action can be filed by a student for a violation of FERPA. It has to be filed through the Department of Education. One of the things you're going to find when you study FERPA law or FERPA policies is that there are no real major cases associated with it. And that's because they haven't happened yet, or because they've been well regulated, or people have not seen enough personal harm to warrant a case. There have been some minor cases, but nothing big enough to illustrate national scale change. Okay? However, there are some best practices to consider. If you are teaching face-to-face classes, do not leave copies of exams with personal information or student performance just laying around. Do not leave any papers, documents with student personal information on an office door, on a board. Do not record attendance by passing around rosters with social security numbers or other IDs. Even saying, I teach a 300-member psychology class, and so I'm going to post all the grades on a door. You're going to provide me a code name, okay, like your, happy student 23. I don't know, I made that up, okay. If a student informs another student of what that code name is, or if it's an obvious one that another student can figure out, it's a FERPA violation, okay. Do not provide grades via phone. Do not provide grades via email that is not in an approved circuit, okay, meaning that generally institutional emails are in protected circuits, meaning they're in the server. So I can communicate grade information to you from email to email, that is University of Memphis email. I cannot communicate your grades to you from the University of Memphis to a Gmail account or a Yahoo account because we cannot guarantee the security of those. Best practices are you should generally communicate grades through online course server systems such as eCourseware, Blackboard, things like that, okay? So beyond that, some other things to consider, do not tell people information over the phone if generally considered a safe information. A lot of times, particularly here in the South, we have this politeness where if people are polite to us, we are polite back to them. And I have seen in registrar's office and in academic admissions many times where somebody will call, I want to know how my grandson is doing, I want to know how my child is doing. Well, we can't tell you that, ma'am. Oh, can you please do it? Okay, I'll tell you just this once. No, that is a FERPA violation for that once. Okay, make sure people in offices are very well trained to understand what they can and cannot do. Okay, so beyond that, let us also look at open records. So now going from protected records to records that are actually open for people to peruse. Now this is a states' right thing. So each state in the nation has different laws that protect open records. Okay, each state can determine if and to what extent records of governmental entities can be viewed by third parties. Okay, and this is completely different based on state. So an example here. Mississippi as a state has legislatively enacted the right for records of any governmental agency to be reviewed by a third party. This is known as the Mississippi Public Records Act of 1983. Okay. However, in individual institutions of higher education in the state, leadership documents can be protected from view. Okay, meaning that if a student wants to research the history of a particular president and institution, the acting president must be sent a request. May I review previous president's diary in the archive, okay? And permission has to be granted. Louisiana, on the other hand, is completely open. A student wants to review any kind of leadership documents at an institution, they can review them as far back as they want to, okay? It's completely dependent on institutional state privilege. Now, there's also something known as the Freedom of Information Act, which highly influences higher education and the documentation that we have. And this is a federal law that allows the public to request information from federal agencies. This becomes particularly important when students are doing data research on institutional records, so contacting another institution's Office of Institutional Research and saying, hey, I need demographic information on your first year class for the last 10 years because they want to see demographic shifts at an institution. Okay. Public records are anything like books, memos, papers, accounts, financial statements, letters, maps, photographs, films, recording, and any de-identified data that can be provided to the public. Okay. Any kind of electronic records, though, law requires that all records, regardless of how they are stored, be available to the public. You need to remember at this point that emails are not your property. Okay, if you have a University of Memphis email address or a university email address or have had them in the past, any email you sent through that belongs to the institution. It is their property. You're using their server. If you have a Gmail account, a Yahoo account, any email you send, it belongs to them. If you have Facebook and you send Facebook messages, guess what? All those messages belong to them. If you text people, any text that you send, including of any images, all of that belongs to that company. AT&T, C Spire, Verizon, they own whatever you send through their electronic means, okay? Property of university or college, all of these things, emails, and as they are the property, they are subject to public records law, which means they can be reviewed if subpoenaed, okay? Internet patterns are also subject to public records law. It's known as file-to-file sharing. Anything I send to you document-wise, anything on Dropbox, anything on cloud storage, if an institution is the holder of that. But also, what is my viewing pattern online? Okay, what am I looking at as compared to things? This is how we actually track down a lot of terrorist behavior for individuals that are actually looking up ways to build incendiary devices or harmful weapons products, things like that. Okay, people do monitor that, right? Now, another thing to consider is the production of records themselves. When we think about the production of them or the destruction of them, some records are kept indefinitely, such as personal records, transcripts, disciplinary records. We keep those forever. Financial records, on the other hand, are usually only kept 5 to 7 years before they're destroyed. There is no state requirement to keep exam papers of students, etc., for any length of time. I generally recommend, if you can, try to save papers for at least one semester beyond the semester in which you taught the individual. Okay. Now that we have all these online systems, such as eCourseware, generally material there is saved for about one semester. After that, though, the course material is wiped. Mainly that's to help with storage. So if you want to keep up with your own materials beyond a semester or two after a class, I highly recommend that you keep copies of everything for yourself. We cannot rely on an institution to keep all of that information because it takes up so much electronic space. However, transcripts and your personal records based on your performance at an institution, that must be kept indefinitely, even long after you've passed away. Okay. There are exceptions to this, of course. Anything protected by another law, such as FERPA or HIPAA. HIPAA, you know, is being medical protection, counseling protection. So anything protected by FERPA or HIPAA is not subject to any kind of open records law. Obviously, attorney-client privilege is not subject to open records law. Any work product of an attorney, not subject to open records. Any personal records or personal transactions, also not subject to open records. Okay. One thing to consider in this is the Patriot Act. The Patriot Act does kind of overgird a lot of rules saying what can and cannot be accessed by the government. And this is something that is dictated by the Department of Justice. It came around in 2001 as a result of the 2001 terrorist attacks on the United States. Okay, this is the Department of Justice looks at this, and it can require the production of otherwise protected documents of suspected terrorists. The actual title of the act is USA Patriot Act, and it stands for United and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism. Okay, so this is kind of the parent law. If you are suspected of any kind of terrorism, and that does not just mean attacking a large-scale building or a large-scale country. This could be, you know, you being an American citizen and wanting to go and cause physical harm to others by using a gun in a public area or a weapon in a public area, or you have built an incendiary device and you want to go to the movie theater and set it off. Anything like that is considered terrorism. Any act performed to induce terror or inflict large-scale harm on others is terrorism. You do not have to be an immigrant. You can be a U.S. citizen and still considered a terrorist. Okay, this is not applied simply to people outside of the U.S. In fact, the vast majority of terrorist-labeled activity happened by U.S. citizens. And by vast majority, I mean over 85 to 90%, okay, are committed by U.S. citizens, all right? Many of which are Anglo-American, meaning they are white male Americans, okay? So the stereotype of what a terrorist is, we really need to bring that into question. Okay, so that's kind of an overview of FERPA and open records law. You notice that there's no big cases associated with it because a lot of this has been handled through regular Department of Education, Department of Justice maintenance, and also any kind of punishments that come with that. Generally, they're financial fees, fines, things like that when there are infractions. All right, we haven't had any massive court cases yet to test it, but we will see what the future brings. All right, so moving from that to athletics. All right, so slide 25 is just a title slide that has, actually that stadium on there is the University of Alabama Stadium in Tuscaloosa, Alabama. Not that I'm a big Alabama fan, it just was a cool picture, so enjoy. Now, when we think about student athletics, and I know we're changing gears here from FERPA and open records to athletics, but it's important we get this in here at the end of the semester. When we think about college athletics, we need to think about the National Collegiate Athletic Association, NCAA. Okay? This is a private voluntary organization which consists of a little over 1,200 institutions. In fact, it's getting closer to over 1,300 now. Okay? They do govern intercollegiate athletics among most of Americans' colleges and universities, and basically they're making sure, they're basically a protecting agency, that your institution does not have to join, but most do, because this actually provides a lot of liability coverage and making sure that Title IX issues are being maintained, financial opportunities are being maintained, that anything dealing with prescription drugs or abused prescription drugs or abused non-prescription drugs in athletes are being taken care of. Anything dealing with sexual misconduct, all of those things are being taken care of, okay, within athletics. We need to go back to negligent liability a bit. You remember that from the first half of the semester. Anytime there is situations of negligent liability, the NCAA does investigate, but it must establish that there exists a special duty of care. You remember all that from the first half of the semester. It's generally assumed that there is no special duty to protect student athletes from harm. This is known as the assumption of risk. Students know what they're getting into. You know, when you play football, you're going to have head injuries. When you are somebody who runs cross country, you may have tendon or knee injuries. The reality that we're dealing with now with student athletes is that students are really not as aware of the potential injuries they may encounter in their sporting events. We assume that they would, but the reality is a lot of research is telling us now that they are not aware of the extent of injuries. They generally have common knowledge of general injuries, but not the extent, okay? Now, the assumption of risk defense is not always a viable argument, okay? And you will remember this court case from the first half of the semester. Okay, here it is again. It's very important for this particular portion. Kleinkinet versus Gettysburg College. And you remember the facts. This was a lacrosse student. He was an athlete. He suffered cardiac arrest and died in an off-season lacrosse practice. Students' parents claimed that if the college had health care nearby, emergency medical procedural staff and materials nearby, that their son may have lived. As a result, they claimed that the institution was negligent and the proximate cause for their son's death. So as the parents claimed, if the institution had proper materials, their son may still have been alive. However, the parents claimed that the college failed to provide properly trained staff at the practice. They did not provide prompt treatment and had no medical emergency plan. The ruling of this case, it was ruled that a special relationship did exist, and it exists due to the recruitment of the student to play for the college, and that foreseeable medical risks could occur during games and practices. Therefore, the institution should have taken precautions against the risk of injury. Not the absolute, it will occur every time, but the foreseeable risk that it could occur. Okay? A special duty of care does not extend to students engaged in unsanctioned activities. Okay, so if it's not something that the university is aware of, so it's an off-campus event, something that's not sanctioned, that is not considered within our purview. All right? So other than foreseeable risk, negligent behavior, like Kleinkinet versus Gettysburg College, we also deal with race discrimination. Title IX of the Civil Rights Act of 1964 prohibits discrimination of race under any program or activity receiving federal funding. So does Title VII, so does Title VI. NCAA attempts to govern this, okay? The NCAA regularly revisits and modifies its eligibility standards regarding its policies that influence racial minorities. Public and private higher ed fall within the scope of this law. It's mainly because federal funds are used a lot with athletic opportunities. Also, Title IX looks probably more heavily at gender discrimination. So under Title IX, institutions must provide reasonable opportunities for members of each sex participating in intercollegiate athletics, meaning do they have reasonably similar scholarship expectations, reasonably similar financial support, reasonably similar facilities. And I don't necessarily mean the field they're playing on. I mean like the equipment. Do they have the same quality jerseys? Do they have the same quality exercise material? The same quality trained staff, trained coaching, things like that. Okay. When we have to look at gender discrimination through Title IX, there is a three-pronged test. This was developed by the Department of Education. In order for institutions to be compliant, they only have to meet at least one prong of the test. Okay? So here are the three prongs. First, participation opportunities are proportionate to gender enrollments, meaning that based on the male-female enrollment, do we have enough proportionate opportunities for male predominant activities, sporting activities, as well as female predominant sporting activities, okay? Or are there more of one gender than the other? The second one is that the institution has a maintained history and continues to practice expanding athletic opportunities to underrepresented sex, meaning that if they see that one gender has had an underrepresentation of opportunities for particular sports, athletic events, whatever, they have to provide additional opportunities. Okay. The last one is that the institution has fully and effectively accommodated the interests and abilities of the underrepresented sex, which goes largely to the second prong. Now, the hope is that the institutions that exist will comply with all three, but the courts have basically said, or the Department of Education has said, really, that they only need to meet one of these. Now, there's also the aspect of disability discrimination, okay, which we do see happening a lot in athletics. We're seeing this a lot more today coming up with unseen disabilities such as mental disabilities, but it still exists with physical disabilities, okay? There are two major disability claims when it comes to disability discrimination. The first is the use of eligibility criteria that directly or indirectly discriminates against the person with a disability by denying them participation on an equal basis with other non-disability participants. Basically, does the sport in question require that the person have the ability that they do not have, meaning walking, use of hands, sight, things like that, to play? Okay? If it does not require those things, then discriminating against them is a problem. All right. The second one is, did the institution fail to make reasonable accommodations to allow full participation by the student athlete with the disability? We see a lot of this now in the use of prosthetics to perform, such as running or jumping or participating in any kind of full contact sports, any kind of cross-country sports. Just because the person is missing a limb, if they have satisfactory prosthetics, should we say that you cannot participate? Okay, now there's arguments on both sides of the fence, particularly as many people claim that these new prosthetics actually may provide additional support to perform better, but really the research is still out on that. Okay, now it is up to the student to illustrate that they have both a disability and that they have been discriminated against. They have to illustrate these things for there to be an actual court case. Okay? For the institution to defend itself, it has to say, if it did discriminate and said, nope, you can't be a part of this, the institution has to illustrate that by allowing the person to participate through a modification, it would fundamentally alter the nature of the activity. Now, this is getting harder and harder to do as so many new prosthetics are available, so many different treatments are available, so many different alterations are available that can allow people to participate, okay? Now, a great court case to consider as regards this situation. Now, this is not a higher ed case, but it does get applied to higher ed quite often. And this is the PGA Tour versus Martin, okay? And this concerned the use of a golf cart for an individual with a disability despite the walking standards imposed by the PGA Tour. Basically, the PGA golf tournament historically does not use golf carts, okay? Part of the tradition of the game is that the golfer has a caddy, the caddy carries the golf clubs, and they walk from driving opportunity to driving opportunity, okay, driving the swing, whatever, okay? There was an individual who was disabled, needed the cart to make it. He was able to perform, but needed that help in transporting himself from hole to hole, okay? PGA Tour said absolutely not. That's not part of the tradition of the sport here on the PGA Tour. This went to court. The court determined that the game was really about making golf shots, not about walking. Okay? The ability to perform the shot, to putt, to drive, and to ultimately sink the golf ball into the hole, that is the perfunctory act of the sport, not walking. So the court recognized the fundamental alteration in two ways. Okay, basically the first one was an alteration affecting the central aspect of the program would be unacceptable if applied to all participants equally. Basically saying that as the sport, the central aspect is not walking, you can give this person a golf cart, but you can also give golf carts to everyone. This tradition that you've imposed on the sport is not necessarily a central component of the sport. Okay. The second one is even a minor change might be unacceptable if it gave the individual with a disability an advantage over other players. One of the arguments that came with this was that if we allow this one individual to use the golf cart, they would actually be less tired when they went to putt, they would not be as exhausted, and therefore they would have an edge over other golfers. Okay, again, the courts came back and said if that is a concern, allow all the players to use golf carts. Okay, again, walking or riding in a golf cart is not a central part of the game itself. So therefore, this is a tradition you've imposed that's not really part of the game. Okay, the same aspects can be applied to any kind of sport within higher education, and we have to consider those two aspects from the PGA Tour versus Martin when we look at any kind of disability accommodations, particularly with physical disabilities. Now, the other one I talked about a minute ago was learning disabilities. The NCAA does contain a series of eligibility acts that addresses learning disabilities. It does comply with America's Disability Act standards, ADA standards, and works to ensure that student athletes and learning disabilities can play as long as the individual meets minimum academic requirements. Okay, this is generally why we provide so much extra tutoring services, so much extra opportunities for student athletes, because many of these individuals get an opportunity to come to higher ed based on a sports scholarship. Okay, this is the way that they're getting in. Now, many of these people are hoping to be drafted, but at the same time, many of these individuals want to finish a degree. As we are bringing here predominantly based on a sports scholarship, we also have to recognize that the purpose of higher ed to exist is to educate people. So, if we're going to bring them here based on a sports scholarship and based on their ability to play, perhaps not for their academic prowess from high school, we need to provide proper opportunities such as tutoring, ability for extra academic engagement to these individuals so they can be successful within the educational front as well as the athletic front. Okay. However, the courts have ruled that if a student athlete scores fall below minimum academic qualifications, granting any kind of waiver for them to continue to play would be a compromise in NCAA's educational standards. Basically, if a student cannot make it in the classroom, we should not allow them to continue to play the sport, because that is an infringement upon the perfunctory act of the institution, which is to provide education to hopefully earn a degree, not time in college to be drafted. Okay? That is a seminal issue that's always a question here. All right? So this was a very, 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 very brief illustration of the NCAA and athletics in higher education and legal issues around it. Okay? So thank you for listening to FERPA Open Records and legal issues with student athletes. The one thing we do need to consider at this point is we've just gone through an entire semester of different legal aspects, from negligence to liability, to looking at free speech, employment, looking at government influence, looking at athletics, protection for students' rights, discrimination, hiring, all these different things. And we have to consider, why is it so important that we are considering all these aspects? Aren't they already at play? The reality is sometimes they are at play and sometimes they're not. Every day violations occur in higher education. The most broken one is actually FERPA. It's generally these little minor things like, oh, I just accidentally told you what Johnny's scores were, or I left this test out and another student saw it. Okay? Violations happen every day in higher education. The biggest thing we need to do is to be prepared to deal with any legal ramifications that come forward, and be prepared to admit when we as an institution are at fault. The problem we are dealing with today in higher education, and we have dealt with historically, is that we are often met with ethical dilemmas of what is best to do. Is it best to break the law, cover up, and have a more efficient whatever in the educational system? Or is it best to follow the law, though it may be more difficult to do, to ensure that equity is served, justice is served, and that all parties are treated in an equal, safe manner? Okay? When I think about this, I think about the future of higher ed, and I think about the choices that all of us have to make. And one of the quotes, which I have on slide 36, which is from J.K. Rowling's fourth book in the Harry Potter series, The Goblet of Fire. This is a quote from Albus Dumbledore, and he says, quote, "Dark times lie ahead of us, and there will be a time when we must choose between what is easy and what is right." Okay? In higher education, just like any organization, we are going to be dealt with many situations when policies come into question, student actions come into question, colleagues' actions come into question, superiors' actions come into question, subordinates' actions come into question. And we must constantly consider what is right versus what is easy to ignore, easy to just allow to continue, easy to not acknowledge and deal with the consequences. Okay? Or we must do what's right for everyone. Do what is right based on the law. Do what is right based on ethics, morality, so that we can move forward as a better society. Okay? Though this semester, when it comes to higher ed law, we have only looked at the snowflake on the tip of the giant iceberg. Okay, I hope you've been provided enough information so that when you leave this class, you can look around and you can see things that you may say, that doesn't seem right, or maybe I should report that, or maybe there's a better way to do this that will be more compliant, and so that it will be more equitable for other people. It'll be less discriminatory. It'll allow people to have free speech where they can question the society or the government of the day, where it will allow people to actually engage in academic learning without fear of reprisal. Okay? So one of the things I do want you to consider after you've listened to this lecture is I've actually got a second link in the module, but it's also a link here on slide 37. And this is a link to an amazing speech that was done by Charlie Chaplin in 1940 in one of his first talking motion pictures. Remember, he was a silent actor, a comedian. And he did a piece that was a social critique on Hitler during World War II, 1940. So World War II was going on 1939 to 1945, and he did a film, farcical on Hitler, known as The Great Dictator. And in his position, he was playing the role of a Jewish barber who was mistaken to be Hitler. Many people at this time period were looking at Charlie Chaplin's look of the small mustache, the combed over hair, and many people were seeing resemblance between him and Hitler. Many people historically have actually said that Hitler had a great appreciation for Charlie Chaplin and so kind of mirrored his look after him. This is debatable, okay? But in this movie, Charlie Chaplin is a Jewish barber. He's mistaken to be Hitler, and so the army takes him and they put him in charge, and all of a sudden he is in charge and he is the great dictator. Okay. Towards the end of the film, he kind of realizes that he doesn't want to be a dictator. It's not his right to do this. In fact, he wants the world to be a good and equitable place. He wants it to be right for children, for the elderly, for everyone to have a good and free life where they can have a chance for democracy, for equal protection, for free speech, okay, regardless of race, class, gender, all of the areas that need protection or have been historically oppressed, okay? And he gives this amazing speech, and this speech in this video, if you'll copy and paste the link from this slide into your browser, or click the link I've provided in the module, it's really a little over 2 minutes, and it's set to all these amazing clips from the media of different things that are happening in society. And what I'd like for you to do is I'd like for you to reflect on the semester. And when you watch that video, it is a very powerful video. Consider how all of the elements we've talked about this semester play into making higher education a better place, and by proxy, hopefully, making society a better place. Okay? So check that out, and I hope you like it, and I hope you've enjoyed all the material this semester. Real quick, I do want to talk about the final exam. The final exam has the exact same format as the midterm exam. There will be 5 case scenarios. You choose the 3 you want to answer. There will be 9 short answers. You choose the 5 short answers you want to answer. I will be sending it out after we return from the Thanksgiving holiday. So you will have an entire week to look it up and answer it. Please make sure you cite the court cases that are listed in the PowerPoint slides and discussed in the videos. Okay. The extra court cases that are in your textbook were to help you with your final paper and for your case briefs or to give you some supplemental knowledge. For the final, make sure you are citing those court cases, okay, that are listed in the slides and discussed in our videos. Those are the most important ones I could provide to you to provide you the most direct information to support your answers. Make sure also when you list them in your responses, you don't just list them. You actually give me some background to them. Give me some information so that I know that you know what the case was about and how it logically supports what you're stating, okay, in your response, okay? So make sure you put in a lot of detail. Make sure you put in a lot of effort. You want to come out strong on this final piece, all right? Also, don't forget that your final paper is coming up. If you have any questions about that final paper, please feel free to reach out to me. If you have any questions about the final assignment in this class, the final exam in this class, reach out to me. It is not comprehensive. It is everything from after the midterm forward. So anything that's pre-midterm is not really going to be looked at, okay? Everything that has been talked about from right after the midterm forward is in the final exam in some way, okay? Exact same format. You've experienced it once, you know exactly what it's going to look like this time around, okay? Everybody, it has been an absolutely wonderful semester, and it has been a delight talking with each of you. I've gotten to know many of you through phone conversations, by stopping by my office, video conversations, and I really, really hope you've also enjoyed the semester. More than anything, I hope you've learned a lot. I hope that you will enjoy reflecting on Charlie Chaplin's video and considering everything that you've learned this semester. Please reach out to me if there's anything I can do for you in the remainder of the semester, but also rely on me as you're in this program in the future. Even if you don't have me for any more classes, or even if you don't have me for a class for a while, if you need anything, please reach out to me. I am here to help you, okay? Thank you all so much for your wonderful papers, your wonderful assignments. Thank you so much for your amazing, brain-teasing questions. They have been astounding, okay? Again, there is a question asking forum for this week, so that link is there as well. I look forward to reading your questions and providing you some feedback on that. Again, if there's anything I can do, please let me know what I can do to help you. Thank you for the privilege of getting to teach you. It has been my honor completely, and I hope that in the future you may take some of my classes, or you may ask just for help on dissertations or research. Anything I can do, please let me know. Okay? Thank you for listening, and I will talk to you soon.